If you are a U.S. citizen, you have the option to file a green card case for your parents. If your parents are located abroad, there are some general concerns that immigration is going to have. The first thing they're going to want to know is, can you prove the relationship? So your parents better be listed on your birth certificate to start. Second, if your parents have been in the United States before, they are going to go into their immigration history to see how often they visited, have they complied with their I-94, have they left every time, concerns that any visa applicant would have. Your parents are considered immediate relatives, meaning that any kind of unlawful stay, if they enter the United States legally with a visa, can still prove that they came in legally, will be forgiven as long as they don't leave the United States. As long as they can prove their legal entry, even if they overstayed, they should be able to get their green card in the United States. There are certain conditions, though, if based on their immigration history, where immigration will force them to go to a local CIS office for interview. So be very careful that you review the case with an immigration attorney before going forward. If your parents are currently in the United States visiting you, I'll say on a B2 visa, and you just became a U.S. citizen a few weeks ago, and you're from India originally, and realized that it was going to take forever as a permanent resident. If you didn't become a U.S. citizen, this was your only route to be able to sponsor your parents. If you apply for them, within 2 months of them coming to the United States because you just became a U.S. citizen, it does look a little contrived on their end that they entered the United States with the intent to move here because their adult U.S. citizen son is now sponsoring them to stay in the United States. So just because they have sponsorship possibilities with their U.S. citizen son for a green card, immigration is still going to look at the doctrine of dual intent, which basically says they came in on a visitor's visa. Were they planning on moving here? Was this the plan all along, that they plan to move here on a visitor's visa, which is a temporary visa, instead of consular processing after the U.S. citizen son became a U.S. citizen? They would interview at the consulate once the immigrant visa is approved and would come in traditionally as green card holders then. Are they trying to avoid that whole process by buying time, by coming in temporarily on a B2 in order to stay with their U.S. citizen, knowing he was going to become a U.S. citizen soon and get their green card that way? So they're really going to look closely at the intent, what was said at the B2 visitor visa interview, what was said at the border, and they're going to look at their surrounding circumstances. When they came here on a B2, did your parents give up their job? Did they give up their land or sublease their apartment? Did they sell their home? Did they close their bank accounts? Things like that show permanence, that they're moving to another country. So be very careful. You need to take into account the same issues in other immigration cases as well as in your parents, what could happen. So always consult an immigration attorney before going forward. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.